Hi, I'm lawyer Jessica Bornick, and welcome to Legal Juice, a vlog of legal information, education, and entertainment. Today I'm going to talk to you about the problems with will kits. Now, first things first, a disclaimer. Although I am a lawyer, I am not your lawyer. Should you require legal advice, please seek the assistance of a lawyer licensed to practice where you are. Do not rely on anything you see in this video as legal advice, and do not delay in seeking legal advice based on anything you've heard in this video. And if you like this video and you want to see more content like this, please be sure to like, share, and subscribe. Now join me. Will kits are legally known as hybrid wills. Now, for the sake of understanding, I will refer to hybrid wills as will kits in this video. Will kits are a hybrid between a handwritten will, also known as a holograph will, and a formal or solemn will, which is entirely typed up. A formal or solemn will is the type of will that is typically prepared by a lawyer. If you want to know more about the 4 types of wills, please watch my video entitled The 4 Types of Wills. Will kits must meet the requirements for a solemn or formal will in order to be legally valid. Now, again, check the laws where you are to confirm the particular requirements, but generally the requirements of a hybrid will are that it must be dated, it must be signed by the testator, meaning the person who made it, it must be signed by 2 witnesses who sign in the presence of the testator and each other, meaning that at the bare minimum, there's at least 3 people present when the will is signed. Now, will kits face a number of issues. Now, the biggest issue is that people don't properly execute them. Some don't realize that they need 2 witnesses, nor do they realize that those witnesses should not be certain people, like the named executor or a beneficiary or a spouse of a beneficiary. If the executor signs as witness to the will, your will be invalidated. Similarly, if you have a beneficiary or a spouse or common law partner of a beneficiary sign as witness, any gift to that beneficiary will be void. So it's very important that you have the proper witnesses sign any will you make so that it's upheld in a probate or surrogate court. Similarly, what happens when the handwritten entries of the maker are scratched out and changed, or there are writing or notes in the margins of the will? The law states that a will must be changed in the same manner in which it was made. So any changes made to a will kit must be witnessed by 2 people. It may be difficult for a witness to remember 20 or 30 years later if that scratch, change, or writing in the margin was there when they signed the will as witness. Now, if the change was made after, then it's not valid, as there were no witnesses to that change. And such a change could potentially invalidate the entire will. Another huge issue with will kits is that many times they're drafted pursuant to the laws of another jurisdiction that may or may not be applicable to where you are. So you need to be careful if you're in, say, Toronto and you're using a will kit from the state of California. Right off the bat with a will kit, you're asked to sign or agree to an ironclad waiver. And I hope I'm not the only one that alarm bells go off when I'm asked to agree to a waiver. Perhaps the biggest issue with a will kit is that people sometimes attempt to gift away property that isn't part of their estate. Now, what do I mean by that? Well, there's 3 types of property for the sake of estate planning. The first is jointly owned property. The second is beneficially designated property. And the third is everything else. Jointly owned property, sometimes called joint tenancy, is property that you own jointly with one or more other persons. The most common example of joint property is a husband and wife owning a joint bank account or a house together. In law, each joint owner owns 100% of the entire property. In other words, each owner has an undivided interest in the whole property. This differs from tenancy in common, where 2 or more persons own property in shares or portions. Under tenancy in common, each owner owns their portion of the divided interest in the property. For example, Jane owns 50% or half interest in a property, and John owns the other 50% or half interest in the property. Joint tenancy is special in law in that it contains the right of survivorship. What is the right of survivorship? Well, the right of survivorship kicks in by operation of law when one of the joint owners dies. The right of survivorship acts to automatically vest the ownership of the entire property in the surviving owner or owners if there's more than one. What does this mean? Well, if a husband and wife owned a home jointly together, upon the husband's death, the entire ownership in the home would automatically vest in the wife via the right of survivorship. As one can see then, because the right of survivorship operates automatically upon death, jointly owned assets are not governed by the terms of your will, and they're not classified as estate assets. You cannot gift away jointly owned assets unless you become the sole owner. The second type of property is beneficially designated property. It is an asset wherein you can name a beneficiary to become the owner or receive the benefits when you die. The most common example of this type of property in Canada are life insurance policies, registered retirement savings plans, pension plans, tax-free savings accounts, etc. This type of property is transferred directly to the named beneficiary upon your death and is not governed by the terms of your will. Lastly, the third and final type of property is everything else that you own. It's assets that you own in your name only, not jointly with somebody else, and assets which you have not designated a beneficiary or owner in the event of your death. These assets are the accumulated or residual stuff in your life. These are what your will governs. So in will kits, we sometimes see situations wherein the husband gifts the farm to his kids without realizing that his wife is a joint owner. The kids have a monetary incentive to take this matter to court and apply to have the joint tenancy severed. And believe you me, when money's involved, greedy adult beneficiaries will take steps to oust their mother from the family home. They may not be successful in litigation, but they will be successful in eating up the estate assets, their own and their mother's funds, in a court battle over your estate. The final issue is that this area of law has evolved from judge-made law, in other words, rulings that were made over previous decades and centuries. Now, I'm talking about Canada, the United States, the United Kingdom, Australia, and any other common law jurisdictions. Some legal phrases in estate law have been interpreted by the courts to have very particular meanings. Those phrases don't always jive with today's grammar. As a result, we've seen in the past a testator striking out a word from an important legal phrase or adding a comma or even removing a comma, and this can bring about a contrary intention to what the maker of the will originally intended. It is therefore really important that you use a will kit that uses clear and plain language, none of the old archaic wills language in terms like per capita or per stirpes, because your will needs to be definitively understood by you and everyone else who reads it. If it is ambiguous, then that's where we're going to see litigation arise. And estate litigation is lengthy, it's time-consuming, and it tends to destroy family relationships. You don't want your legacy to be a broke and broken family. Although a will kit may be at first glance a more economical option for you to make your own will, your best route that has the best chance of reducing litigation over your estate after you die is to have a lawyer who specializes in wills and estates prepare your will for you. Your second best option is to make what we call a holograph will, also known as a handwritten will. And to see how to make one, be sure to subscribe and hit that bell to be notified of my next video release, wherein I show you how to write your own holograph will and go through step by step the elements of what should be included. Thanks for watching.